we've only got 1 hour, so it's a great pleasure to have Marcus Teo here to speak to us this afternoon. He very kindly accepted my invitation to speak here, and in return, he's also agreed to speak to the Asian Private International Law Academy based in Doshita University next week.
This is now on record, I suppose. Thank you, Judge Reyes. It's a tremendous pleasure to be here. Thank you so much for your hospitality. It's been wonderful. I now love Hong Kong, and if you have me, I'll come back again. And I'm so glad to have such an esteemed audience here today. I'm just going to be talking very briefly about an aspect of the law or the common law on jurisdiction agreements, which you might know here as the strong cause test, right? The background is simple. In the common law, jurisdiction agreements are contracts. They are treated like ordinary contracts, which means that they are written like, interpreted like, and enforced like ordinary contracts. In particular, this means, however, that specific relief is usually available for a breach of a jurisdiction agreement. A stay of English proceedings, if the jurisdiction agreement is an English jurisdiction agreement, or anti-suit injunction restraining foreign proceedings, if the foreign proceedings are brought in breach of the English jurisdiction agreement. Sorry, I should have said a stay of English proceedings if the jurisdiction agreement is a foreign jurisdiction agreement, right? So generally, we get the contractual picture. They are enforced like contracts in the sense of specific relief because damages are not typically an adequate remedy. But there's an aspect about the law on jurisdiction agreements which doesn't quite, at least at first glance, fit with the contractual account, and that is the strong cause test. Right? It is a test that enables a court to refuse to enforce a jurisdiction agreement in the sense of giving specific relief when it finds strong cause to on the balance of several factors. Proponents of the contractual account, which is essentially everybody in the common law, will say that the strong cause test is a contractual defense. Indeed, it is. It must be if jurisdiction agreements are contracts. But what kind of contractual defense? Why does it exist? And why does it look the way it does? I think these questions might need a little more explication for a satisfactory answer to be found, and that is my task today. I will be speaking primarily about English law. So when I speak about foreign or forum, local jurisdiction agreements, I will use the term English jurisdiction agreement, although this analysis will apply equally to and will draw from Canada, Singapore, Hong Kong, not Australia, for reasons unique to the Australian view on the exercise of jurisdiction in private international law. So I don't think I really need to say very much about what the strong cause test is, but I will do so anyway, very briefly to set the stage before I try to explain why I think it looks the way it does. So a court will generally, an English court will generally stay English proceedings in the face of a foreign jurisdiction agreement, an exclusive jurisdiction agreement, and will generally restrain foreign proceedings in breach of an English jurisdiction agreement unless there's strong cause not to. Now, the strong cause test involves a balance of several factors. First, there are what might be termed convenience factors, where the parties are located, where the evidence is, what the governing law of the claim is. These factors are relevant to the strong cause test, but they're not typically thought to hold much weight. They don't typically suffice to establish strong cause unless they are unforeseeable by the contracting parties at the time the jurisdiction agreement was entered into. So if parties foresaw a dispute for which these convenient factors are relevant, the fact that it is now inconvenient for parties to go to that chosen court will hold very little weight in the strong cause analysis. The idea, I suppose, is that they've chosen to go there. They should lie where they've made their bed. On the other hand, there is another factor which we might term the fair trial factor, or the risk that parties will face an unfair trial in their chosen court. This factor is said to be qualitatively different from the convenience factors in that typically, if you can show that in the chosen courts, parties will not get a fair trial for racial, religious, or other political reasons, or perhaps a sheer lack of institutional support to even bring a meaningful claim, then that will typically by itself suffice to establish strong cause. And importantly, it's typically not very relevant or not very significant, even if not entirely irrelevant, that the prospect of the unfair trial in the chosen forum was foreseen. The fact that parties foresee it is actually usually nothing to the point. Third, there is what I will call the related proceedings factor. The fact that there are proceedings relevant to the same underlying disputes, which are happening somewhere outside the chosen courts, So let's call this place the Ruritanian courts, is a relevant factor in the strong cause analysis. If A and B, parties to the jurisdiction agreement, have chosen the UK, but an aspect of their dispute is being litigated in Ruritania, that might give the courts reason to disregard an English jurisdiction clause and stay proceedings in favor of Ruritania. But whether or not the courts will consider this a very weighty factor really depends on who the parties to those parallel proceedings in Ruritania are. If they are the same parties to the jurisdiction agreement, A and B, courts will typically think this is immaterial. Parties should have foreseen this. Indeed, they probably would have foreseen it. And the parallel proceedings are merely a self-induced inconvenience. The courts will give this very little weight in the strong cause analysis. But if the parties in the Ruritanian proceedings are not A and B, but A and C, a non-party to the jurisdiction agreement, now that becomes a rather weighty factor because the parallel proceedings involve a third party who's being, and if those proceedings were allowed to be fragmented because of the jurisdiction clause, this third party would be, in a sense, having to face fragmented proceedings due to an agreement not of his own doing. In that situation, it is rather less relevant that the fragmentation of proceedings was foreseen by A and B because this concerns C. Finally, there is one other aspect of the strong cause test which we should tease out, which is that it is relevant that parties entering into the jurisdiction agreements are roughly of equal bargaining power. Not that they must have actually negotiated the agreement, but they must have had a genuine opportunity to negotiate the agreements. If the agreement is between sophisticated contracting parties with the genuine opportunity to negotiate their chosen forum, the strong cause test will apply to the hilt. On the other hand, there is dicta in the English courts, suggestions in the Singapore courts, and a confirmation by the Supreme Court of Canada recently that when parties are of unequal bargaining power, the party with weaker bargaining power may need to show less to establish strong cause. In English law, there's a variant of this relating to trust beneficiaries and their ability to invoke the strong cause test. Trust beneficiaries are bound by a jurisdiction clause entered between the settlor and the trustee. But they do not typically need to show strong cause to avoid the jurisdiction clause. The reason, said Lord Neuberger and Crociani, is that their commitment to the jurisdiction clause is not of the same level as the contracting parties, i.e. they didn't bargain for it, and so they're not held to it at the same standard. So unequal bargaining power affects the strong cause test. So I think I've roughly set up the strong cause test. Before I say what I think the strong cause test is, I suppose I should say it right now. My argument will be that the strong cause test is a contractual defense that preserves the doctrine of forum non-convenience. So in my accounts, every jurisdiction agreement that prevents the English court from exercising its jurisdiction in line with the doctrine of forum non-convenience is unenforceable. But logically, the fact that parties have entered into the jurisdiction agreement should hold very significant weight in the forum non-convenience analysis, which leads almost inexorably to the outcome that in most cases, the jurisdiction agreement choosing a particular court will give the English court strong reason to think that the chosen court is in fact the most appropriate forum for trial, unless there's strong cause to think otherwise. I will flesh that out in a second. Before that, I will, I suppose in the interest of time, very quickly address two accounts of the strong cause test extant in the literature, which I think are not particularly satisfactory. The first comes from Richard Fenterman. Fenterman has written that, Fenterman has written that the strong cause test is like an implied term that parties should not be held to the agreement to sue and be sued in a particular place if circumstances fundamentally change. In other words, the strong cause test is, amongst other things, a doctrine of frustration. This account, however, is not particularly popular, and it's easy to see why. It explains some aspects of the strong cause test, like why foreseeable convenience factors cannot generally establish strong cause, and why self-induced parallel proceedings cannot generally give rise to strong cause. Foreseeable events do not typically frustrate contracts. Self-induced frustration is typically not frustration. But as I said earlier on, there are a few factors in the strong cause test, notably the fair trial factor and the related proceedings involving third parties factor, which can suffice to establish strong cause, even if they were foreseeable by parties to the contract. So I think that is enough to say that the frustration account is not particularly accurate. The second account is rather more nuanced. which is that the strong cause test is not actually an implied term or contractual defense, but it's an exercise of remedial discretion. Various authors in various aspects of their work have sort of tentatively committed to this view. Authors like Dan Tan and Nick Heo, Albert Donnelly, Ed Peel, and in some of his work, Adrian Briggs, I think, if I'm reading that correctly. The account goes something like this. When the English court finds strong cause not to give effect to the jurisdiction agreement, it's not actually denying enforcement of the jurisdiction agreement. Rather, it's simply alternating the remedy it gives, not not a specific remedy in the form of a stay or an anti-suit injunction, but damages for breach of the jurisdiction agreements. Now, this account does make some sense of some aspects of the strong cause test, like why third-party interests, i.e. the interests of the third party, C in Ruritania, can give rise to strong cause. Third-party interests are typically not enough to create a contractual defense, but they may be enough to justify the variation of remedies in the exercise of remedial discretion. The difficulty, however, is that most of the time, in fact, almost all the time, when courts find strong cause not to enforce the contract, they don't grant damages, not even nominal damages. They grant no remedy at all. It is in fact, and it's also no answer to say that parties do not specifically plead damages for breach of the jurisdiction agreement is an alternative, because damages in lieu of specific relief are available even if the court doesn't plead it. So if the parties don't plead it, yet the damages are not typically available. There are cases which suggest that these damages in lieu of specific relief for breach of the jurisdiction agreement, damages to neutralize at any rate in commercial terms any benefit to defendants of the foreign judgment obtained in the foreign non-chosen court can be awarded. That's from the Alexandros T of the UK Supreme Court. But the Alexandros T is an interesting case because then the UK was still part of the EU. Then the anti-suit injunction sought by could never have been sought by the party relying on the jurisdiction clause because the foreign proceedings, which might have been restrained, were Greek. So it seems that the only case where one of the only cases where courts have granted damages in lieu of specific relief is in this context where the court couldn't have granted specific relief in the first place. All this is to say that the strong cause test is not typically the exercise of remedial discretion. It is in fact what might loosely be termed a contractual defense, a rule barring the enforcement of a jurisdiction agreement when strong cause is found. So I've said what I think it is not. Now I shall say what I think it is. The strong cause test is often said, and I think this is the dominant account of the strong cause test, to reflect the rule that contracts cannot oust the jurisdiction of the courts. This is a view that basically all major scholars in the field share. Adrian, Ed Peel, Alex Mills, Louis Murray, Yeo Tiong Min. At various points of their work, they've always committed to the view that the strong cause test reflects the ouster doctrine. Contracts cannot oust the jurisdiction of the courts. And in Dewars and Facebook, the Supreme Court of Canada explicitly endorsed this view. I think this view is correct, but I think the account must be refined in a few ways. First, what the strong cause test is prohibiting is not contracts that oust the existence of the jurisdiction of the English courts, but rather contracts that oust the English court's power to determine how it exercises its jurisdiction. Because this must be so, because otherwise, if the strong cause test were targeted at contracts ousting the existence of the English court's jurisdiction, then it should be hard to think why any English jurisdiction agreement could ever be denied enforcement on grounds of strong cause. Because an English jurisdiction agreement doesn't oust the jurisdiction of the English courts, rather it creates it. Yet both English and foreign jurisdiction agreements are subject to the strong cause test. What it is concerned with then is the power to exercise jurisdiction of the English courts. There is a second problem though with the ouster account, and it is this. If the strong cause test exists to protect the power of the English courts to determine how it should exercise its own jurisdiction, then why doesn't the strong cause test look like the test that the English courts typically apply to determine how to exercise its jurisdiction? Forum non-convenience. After all, the strong cause test exists to prohibit contracts ousting X. The strong cause test should look like X, but it doesn't. It looks kind of like X. It has similar factors, but there's one crucial difference. It's pegged at a much higher standard. Indeed, that's its defining trait. Strong cause, not just on the balance of convenience or appropriateness. So in order for the Ulster account to work, I have to say that forum non-convenience and the strong cause test are actually one and the same. That is a view that William Day and Mr. Justice Marcus Smith have committed to in various recent writings. I think they are correct, but they do not explain why they're correct. So I shall now attempt to explain why I think they're correct. This is why. First, we must understand what forum non-convenience assesses. Forum non-convenience is an assessment by the English court about whether it or another court is the most appropriate forum for trial. Appropriateness here means at least three things. It means effectiveness. The appropriate forum must be able to effectively resolve the dispute, must actually hear the dispute, it must actually be able to bring the dispute to some kind of terminus. The appropriate forum must be convenient. Parties must not go through significant time and expense litigating there. It must be easy for parties to litigate there, or at least easier than anywhere else. And most fundamentally, it must be accurate. The court's resolution of the dispute must be correct, or at least as more correct than any other competing court. It must get the facts right. It must get the law right. And when the law is foreign law, it must get foreign law, which is a fact, correct as well. These three factors illuminate the factors under forum non-convenience, why the available forum is only the appropriate forum if it is in fact available, why witnesses, evidence, and the governing law are relevant factors, why an unfair trial in the prima facie convenient forum or appropriate forum is such an important factor to consider whether or not it's in fact the appropriate forum, because an unfair trial is by definition an inconvenient and inaccurate trial. So forum non-convenience is about assessing comparative appropriateness of the English court and the foreign court. But the English court is not the only entity in the English proceedings which will form a view about the appropriate forum. The parties will as well, if they've entered into a jurisdiction agreement. Parties do two things, generally, I think we can say, when they enter into a jurisdiction agreement. One, they enter into obligations to sue only and be sued in their chosen forum. Two, they typically, though not invariably, and I shall say something later about the exceptional circumstances, but typically, they also express a belief when contracting that their chosen forum is the most appropriate forum for trial. It is the most effective, it's the most convenient, it's potentially the most accurate. They form a view on this. And importantly, at least most of the time, we have reason to think that the parties are fairly well placed in coming to this conclusion. In fact, they may be better placed than the English court itself, because the dispute is the parties' dispute. The facts relate to the parties. The transaction is the parties. Together, acting ad idem, they know everything there is to know about the dispute, potentially. At least if the dispute is foreseeable at the time when they enter into the agreement. And so, generally, the parties' views reflected in the jurisdiction agreements that their chosen court is the most appropriate forum for trial should generally be weighty evidence for the court that that chosen court is in fact the appropriate forum for trial, is in fact forum convenience. Now, what is the court to do with this well-informed view of the parties that their chosen court is the appropriate forum? The court can disregard it, but that would seem to be unwise. The court can defer unconditionally in it, but that would be abdicating its adjudicative responsibility. The court should, I think, take the parties' views as weighty evidence that their chosen forum is the appropriate forum for trial. Generally, parties will be correct. Generally, then, the court should agree with the parties, not because it's bound to, but because it just makes sense. You should typically listen to the views of someone more well-informed than you on a matter that you're trying to adjudicate. But typically, listening doesn't mean always listen. Right? I guess the position may be analogized to how courts treat uncontroverted expert evidence. The courts will give effect, will follow, will agree with uncontroverted expert evidence unless the evidence looks obviously wrong. So the courts will follow the parties on their views as to their appropriate forum, unless there's very good reason not to, unless there is strong cause not to. So that is my account of the strong cause test. It is a doctrine which prevents contracts from ousting the doctrine of forum non-convenience. But forum non-convenience itself, the search for the appropriate forum, should give weight to the jurisdiction agreement most of the time. I guess I can quickly say something about what you might think is the artificiality of this analysis. Parties don't typically always think when they enter into agreements that when they choose their court, that is the appropriate forum for trial. But we might infer that they do. After all, parties, when they enter into a contractual agreement, typically, though not invariably, think that that agreement fits their interests best. And if the subject matter of the contract is where they should litigate, parties will typically, though not invariably, think that the forum that they choose is the best forum to litigate in. And so the courts, in searching for the appropriate forum, should typically follow this line. The idea that contracts can both reflect agreements creating obligations and agreements reflecting parties' belief that their obligations are what's best for them is actually not uncommon to the common law. It's what courts say when they give effect to the doctrine on the rule against penalties. Right? It is said that a liquidated damages clause is enforceable. It always confers obligations, but those obligations are only enforceable to the extent that the liquidated damages clause reflects a not disproportionate, is not disproportionate, a loss not disproportionate to parties' legitimate interests when entering into their contracts. And when parties are commercially minded parties, courts will give significant weight to their view because typically they're better placed in the court to figure out what a proportionate response to their legitimate interests is. But when there is very good reason, despite the contract, to think that the legitimate interest lies elsewhere, the courts will deny enforcement to the liquidated damages clause. And I think the same analysis can be said for jurisdiction agreements. So I've engaged for the past 20 minutes in somewhat empty theorizing. Let me now try to establish why this makes some practical difference. First, I will say why my account of the strong cause test explains aspects of the strong cause test, which I've just laid out earlier on. First, let's note the logic again of the strong cause test. Courts will always exercise their jurisdiction in line with forum non-convenience, but they will typically give effect to the jurisdiction agreement because that typically represents parties' well-informed views as to the appropriate forum for trial. But this logic necessarily gives rise to two exceptions. One, where exceptionally, parties are not actually well-informed as to where they as to whether or not their chosen court is the appropriate forum for trial, or parties couldn't have been well-informed because they are not well-positioned epistemically to be that well-informed. Two, where despite parties being well-informed, court has a very strong other reason not to give effect to parties' views. And I think these two situations, these two exceptions, can explain much of the strong cause factors. First, convenience factors. Why is it that convenience factors are typically insufficient to establish strong cause unless they are unforeseen? It's because typically parties will know very much about the factors which relate to whether or not one forum or another is convenient for their dispute, because parties know about their dispute. That is par excellence the thing that parties know very much about. And so courts will give significant weight to the parties' views thereon, unless the dispute is something that parties could not have foreseen. Because then their view that their chosen court is the appropriate forum is not well informed. They didn't expect this dispute. Surely then their view should hold little weight. Second, the fair trial factor. There are two reasons why the fair trial factor is typically of very strong weight. One, the fact that a particular chosen court is going to be politically biased against one of the parties is not necessarily something that the parties are better placed to know than the English court. I think the extent to which another court is prejudiced or politically compromised is something that is not so close to the party's knowledge in the way that aspects of their dispute is. So there's no real reason to think the parties are better placed at the court to know about that. Second, of course, the lack of a fair trial at the chosen court strikes at the heart of appropriateness. An unfair trial is by definition inconvenient for the prejudiced party and by definition inaccurate for both the parties, even the party that stands to benefit. And so it is typically the fact that the unfair trial will likely occur in their chosen court is typically very strong reasons to balance against what might also be a strong reason to follow the jurisdiction agreement that parties might potentially be well informed. A strong reason against a strong reason doesn't necessarily lose out. Third, I think we can now see why parallel proceedings which do not involve the parties to the agreements are very weighty factors in the strong cause analysis. A and B are well informed about what the appropriate forum for their dispute between them is. They are not typically well informed about the appropriate forum for the dispute between A and C. It could be the jurisdiction agreement could reflect a collective view on the most appropriate forum if C were party to it too, because C would be able to give inputs, but C was not. And so in finding the appropriate forum for trial of the dispute, and not just A and B's bit of the dispute, it is incumbent on the court to consider whether or not the parallel proceedings involving C might establish strong cause. Finally, the lack of equal bargaining power. The idea that the jurisdiction agreements reflects parties' well-informed views as to the appropriate forum for trial presupposes that parties had the ability to form equal views on the point. If one party is capable of overbearing the other party, then it just reflects only one party's views as to where the appropriate forum for trial is. And then it no longer represents a collective view of the appropriate forum for trial, which would be a comprehensive view of the appropriate forum for trial for both A and B's disputes. And then the court has no great reason to give effect to the jurisdiction agreement. I have, I think, 5 minutes more. So I will quickly now draw two implications, I think, of my analysis of the strong cause test for interesting aspects of the application of the strong cause test to certain jurisdiction agreements. First, to English non-exclusive jurisdiction agreements. If an English court is deciding whether or not to stay its proceedings and one of the litigants relies on an English non-exclusive jurisdiction agreement, does the party seeking to get the stay of the English proceedings have to show strong cause to depart from the English non-exclusive jurisdiction agreements? If we think of the strong cause defense as just a defense to a breach of a contractual obligation, the answer should be yes, right? Because an exclusive agreement is an agreement to sue and to submit to be sued in their chosen courts. The non-exclusive agreement is agreement not to sue only in the chosen court, but to submit if sued in the chosen court, which means there's an obligation to submit if they're sued in the UK, if there's English non-exclusive jurisdiction agreement. So the party seeking to avoid that agreement should typically have to show strong cause. But if we think about the nature of the contractual defense, another answer becomes apparent. The former answer is the answer reached by the Singapore courts and the Hong Kong courts, that you have to show strong cause to avoid the local non-exclusive jurisdiction clause. And earlier, English courts seem to endorse this position wholesale, but at least in recent decisions like Highland Crusader, the English courts have started to say something slightly different. The non-exclusive jurisdiction clause is strong reason to think that the UK is an appropriate forum for trial. Why is that so? Let's think about it. The reason why the strong cause test imposes such a high standard for the exclusive jurisdiction clause is because when parties enter into that clause, they're sharing a belief that their chosen forum is the most appropriate forum for trial. But when they enter into a non-exclusive jurisdiction clause, what they're expressing is, in Mr. Justice Hobhouse's words, a view that their non-exclusively chosen court is an appropriate forum for trial. It therefore follows that if the court is to apply forum non-convenience and to look at the non-exclusive jurisdiction clause, it should not consider the non-exclusive jurisdiction clause a very weighty factor, because all it expresses is parties' view that the UK is an appropriate forum for trial, not the most appropriate forum for trial. Finally, I want to say something about anti-suit injunctions. There are two kinds of anti-suit injunctions, non-contractual and contractual. In Airbus and Patel, we hear that the English court, in order to issue a non-contractual anti-suit injunction, the applicant must show that the English court has jurisdiction over the injunction respondent, that the UK is forum convenience, the natural forum, and that the foreign proceedings are brought in what might be termed a private law wrong, an equitable wrong. They are vexatious and oppressive, brought there by the injunction respondent. Then the English court will issue the non-contractual anti-suit injunction. The test looks different for the contractual anti-suit injunction. There are only 2 requirements, not 3, says the House of Lords in Donoghue and Armco. The English court must have jurisdiction over the injunction respondent, and there must be an English exclusive jurisdiction clause. That's it. Why the disparity? In the former, the UK must be forum convenience. In the non-contractual context, the UK must be forum convenience, the natural forum, because it is said that comity is a concern. But in the contractual setting, it is said that comity is not a concern. We're just enforcing an agreement. That would be convincing if English courts did not themselves take affront or umbrage at the fact that when a foreign court issues an anti-suit injunction, a contractual anti-suit injunction against the English court does in fact take umbrage. It seems that in the contractual context, comity too is a concern, even if the English courts will not admit it. So why the disparity? Why does why does the UK have to be forum convenience for the non-contractual injunction, but not the contractual injunction? I think actually there's no disparity. We can say that even for contractual injunctions, there is a need for the UK to be forum convenience. It's just that when there is an English exclusive jurisdiction clause, the UK is almost by definition the natural forum, unless there is strong cause for you to think otherwise. Because on my account of the strong cause test, it is just forum convenience, forum non-convenience, the test, I mean. So if there's an English jurisdiction clause, and there's no strong cause not to give effect, then the court necessarily will conclude that the UK is the natural forum. So there's unity in the law between contractual and non-contractual anti-suit injunctions. What is the point of unity? Is it just a nice thing to have? Scribbled on my list here, the last point I want to make relates to UniCredit and Ruschem Alliance. There, the English Supreme Court last year, in the sole judgment of Lord Leggett, issued an anti-suit injunction restraining arbitral proceedings, restraining judicial proceedings in Russia brought in breach of a Parisian arbitration clause. So the idea was that here, the UK could restrain Russian proceedings, even though the UK was not the natural forum for trial, because it was just enforcing an agreement. In doing so, the UK Supreme Court went against the preponderance of academic opinion to that point, thinking that you could not issue an anti-suit injunction to restrain foreign proceedings unless the UK were also the natural forum for trial, unless the UK had something to do with the dispute. The anti-suit injunction, in other words, couldn't be freestanding. If the consternation about UniCredit is to be, and I will assume that there's some degree to be concerned about UniCredit, and it will lead to some kind of arms race to common law jurisdictions to get freestanding anti-suit injunctions against proceedings that have nothing to do with them. We might want to confine UniCredit to the arbitration context and to say that in the litigation context, we cannot issue these freestanding injunctions. But why not? If the freestanding injunction is just an enforcement of the contract, if it's just the application of the test for the contractual injunction, the answer, I think, can be this. Even in seeking the contractual injunction, the UK must be the natural forum. And it will only be so if the exclusive jurisdiction clause the injunction is sought to enforce is an English exclusive jurisdiction clause, because only then will the UK also be the natural forum for reasons I've explained. If you're trying to give effect to a Parisian jurisdiction clause, that will not lead you to the conclusion that the UK is a natural forum. That will not lead you to the conclusion that the UK should issue an anti-suit injunction restraining the Russian proceedings. Thank you.
Thank you, Marcus, for the presentation today.